Waiting for people. Hi everyone. Is everybody, hopefully everybody's here. We had a bit of a technical glitch. Apologies for those waiting, and I appreciate your patience with that. So we'll get cracking now. Hopefully, that will be it for the technical problems. Hello, welcome to our webinar. Today we're focusing on the Employment Rights Act 2025 and what that means for employers. Okay, I'm Liz Chiver and I'm the Director of Halliday's HR. And this is my colleague Lizzie Walsh, and she's our HR business partner. I think quite a few of you will recognise our faces. I know that there was quite a few familiar names on the register list. So hi to all of you. But for those of you who don't know us, then Halliday's HR is a HR training and financial recruitment consultancy based in Stockport, but we do deal with small businesses across the whole of the Northwest. We're recording today's webinar and we will be sharing this with you after along with a copy of the slides. We can see you if you've got your cameras on, that is, but we can't hear you as we've turned your microphones off. So please, if you could use the chat function for any questions, then we will try to go through those towards the end of the presentation. So the Employment Rights Act 2025 is one of the most significant employment law reform programs in recent years. However, before you panic, most of the major changes don't take effect immediately. They are phased across kind of 2026 and 2027. So it does give you, a bit of time to prepare, but it does mean that there is quite a lot coming down the line. So today we're going to cover what's changing, the timeline from, 2026 over 2027, what this means for businesses, practical actions to prepare. So our aim is kind of not to overwhelm you with all of the legal detail or the legal jargon. Instead, what we're kind of going to focus on is, what's actually changing, when it takes effect, where businesses face the greatest risk, and what you should be doing now to stay compliant and prepared and to protect your business. So, our overall aim is that you leave this webinar feeling informed, clear on priorities, and confident about those next steps. So why does this new act matter to businesses? So there are three key themes running through this act. So the first is that employees gain protection much earlier. So the qualifying period for unfair dismissal is expected to reduce significantly, which changes how probation and early employment risk is managed. And we will cover more on this later. The secondly is that the financial exposure increases. So compensation caps are being removed, protective awards are doubling, and tribunal time limits are increasing. And finally, employers are expected to be proactive. So this is particularly around harassment prevention, documentation and consultation. And historically, many businesses have relied on a more informal management style, those quick conversations, the flexibility, and, those pragmatic decisions. And, we're not saying that those approaches, are wrong, but all we're kind of highlighting here is that they may become a little bit riskier under this new act, okay? Because that legislation is pushing businesses towards a much more structured, documented HR practices. So it's helpful to see this as a staged reform program. So this is the overview for 2026-2027. So in February 2026, there were changes introduced around industrial action. Also from the 18th of February, employees could start giving notice that they intend to take parental leave or paternity leave under the new eligibility rules that come into effect from the 6th of April. So April 2026 is the first major implementation point particularly around that family leave, but also around sick pay, whistleblowing, and redundancy penalties. Then October 2026, this brings significant changes around harassment liability and tribunal time limits. And then the headliner is the January 2027, when the unfair dismissal changes take effect. And then throughout 2027, we're likely to see structural workforce changes, so around the 0 hours contracts, shift notice, around flexible working and redundancy consultation. So it's not just one change, it is a rolling program over the next 2 years. The 6th of April, 2026, paternity leave and unpaid parental leave are becoming a day one right. So currently employees must have 26 weeks service to qualify for paternity leave and 1 year's service for unpaid parental leave. However, that service requirement is going to disappear. So in practice, someone could join your business and on day one, they inform you that they intend to take paternity leave. However, it is worth noting here that, in order to be able to be paid that leave, so to qualify for the statutory paternity pay, the service requirement for that still remains unchanged. Also from the 6th of April, employees gain a statutory right to bereaved partners' paternity leave. So this is extended leave if their partner, so, the child's mother or the primary adopter, dies within the first year after birth or adoption. So the extended leave is up to 52 weeks and it must be taken within 52 weeks of the child's birth or adoption placement. And this will also be a day one right. The leave is unpaid, although obviously with all of these statutory requirements, employers may wish to offer some contractual pay around that and some form of enhancement. The leave comes with employment protections, meaning that the employee has they've got protection from dismissal or detriment for taking the leave. They've got a right to return to the same job or a suitable alternative in limited cases, and enhanced redundancy protection during the leave and for a period afterwards. So, for smaller teams, this may have, quite a big impact. They're often those tightly, they've got quite tight structures around them. So, losing someone unexpectedly, even on a temporary kind of basis, can still create that pressure. So, as such, you might need to do things like, have clearer leave notification procedures, look at having improved workforce planning, update your family leave policies, and also look at some manager training on how to handle requests consistently. Okay. So the consideration here is really how to be, operationally prepared for these entitlements coming in. Also from April 2026, the statutory sick pay becomes payable from the first day of absence. Okay, so currently we've got 3 waiting days before SSP kicks in. I've got to put my teeth in, but this will be removed. Okay, so it will be payable from day one. And also the SSP rate is expected to increase as normal, as expected, and it'll be increasing from £118.75 to £123.25. Okay. Additionally, so there is some criteria around whether an employee qualifies for SSP. And one of those is changing. So the lower earnings limit is being removed as of the 6th of April. So it just means that more workers are going to qualify for SSP. This, of course, is going to have increased costs for businesses, particularly, for those businesses with part-time or lower paid or, those shift-based employees. So, the real consideration here for us will be around, your absence management procedures, making sure that you've got clear reporting procedures, that potentially you've got trigger points for managing absence, that you're doing the return to work discussions and that you're having them after every single absence and that you're, recording them on a return to work form, putting them on the personnel files, and the monitoring of that, those short-term absence patterns. Because potentially this is going to be on the increase, so we really need to kind of tighten up those controls. So yeah, so like I say, now's a really good time to review your absence management procedure before these changes land. Obviously, I appreciate that you probably only got about 10 days before it lands, but if you can just have a look at them and just kind of see, potentially this is what we need to focus on and really kind of hone in on that. Okay, on that note, I'm going to pass over to Lizzie.
Thanks, Liz. So, in terms of collective redundancy changes, then, so from April 2026, collective redundancy consultation requirements will apply when an employer proposes dismissing 20 or more employees within a 90-day period. So that award for failing to consult when going through redundancy is going to double to 180 days. Okay, so next year, redundancy thresholds will be calculated across the whole organisation. So if you've got businesses that have individual sites, it's not redundancy is happening in one site, therefore you don't need to consider the 180 days. It will be across the whole organisation. Redundancy planning must therefore be strategic as opposed to reactive, because the financial penalty for getting it wrong will become significantly higher. We've then got the Fair Work Agency, which is a new UK enforcement body created under the Employment Rights Act 2025. So this is designed to bring together and strengthen the enforcement of key workplace rights, effectively acting as a single, more powerful labour market regulator. So the idea being is that the Fair Work Agency will centralise enforcement from April 2026, which suggests that there will be kind of this more coordinated oversight and potentially more proactive investigations. So things like payroll accuracy and compliance, documentation will all become increasingly important, more so than it already is, I guess. We then have whistleblowing and sexual harassment. So this is probably one of the most significant risk areas in the Act. So from April, sexual harassment will become a qualifying disclosure under whistleblowing law. So what this means is that if an employee raises concerns about sexual harassment, they gain whistleblowing protection. So they are protected not only from dismissal, but from any detriment. What will then happen in October 2026 is that employers will become liable for harassment by third parties. So this is if you have employees that are going out to client meetings, you may well have delivery drivers that come to your site. Anybody external to your business essentially will class as a third party. So unless you can show that you have taken all reasonable steps to prevent third-party sexual harassment, then you'll be in a bit of bother, I guess. And the shift essentially is from reasonable steps to all reasonable steps, and this is where the bar really raises. So for businesses, this means that you must be able to evidence that you have a clear anti-harassment policy, that you've got reporting mechanisms, that you are carrying out risk assessments, that you are training your managers and carrying out employee awareness training, and you ultimately have documented preventative action. Okay, so basically anything that you do to prevent any form of sexual harassment including third-party sexual harassment, must be documented. Because if something happens and you cannot demonstrate that you have taken a proactive prevention, then that exposure increases significantly. Okay. So we then have, from October 2026, the time limit for bringing most tribunal claims. It's going to increase from currently 6 months, it's going to increase to 6 months, so it is going to double. So effectively your exposure window is doubling. So it means that employees have longer to bring a claim. So this change does therefore increase the importance of retaining your documentation, making sure that you're following structured exit processes, perhaps a time to think about whether it's worth doing exit interviews if you don't already. Perhaps it's about considering the use of settlement agreements as a potential way to exit people that bit easier, albeit I appreciate sometimes costly, but it's certainly about having those consistent performance management records, because ultimately your documentation must be able to withstand scrutiny 6 months later. So it's certainly worth taking a look at your data retention policy to make sure that you are retaining that data accordingly. And next up then is the unfair dismissal changes, which is arguably the most commercially significant change for businesses. And potentially, never mind your Christmas shopping and organising your Christmas parties, Christmas 2026 could be a really busy time for businesses and indeed us in HR as they look to remove people. Okay, so first off, just to advise that from the 6th of April, the compensation cap that is already in place will increase to £123,543. But then the plan in January is that that will be scrapped. So that compensation cap will be removed. So unless things change between now and the 1st of January 2027, and who knows, watch this space, I guess, but as it currently stands, unfair dismissal protection will begin after an employee has 6 months of service, not the current 2 years. So currently that 2-year qualifying period does provide you guys with flexibility when managing performance or that cultural mismatch. However, reducing it to 6 months changes that early employment risk entirely, as after 6 months service, an employee will have employment rights. So whilst having a probation period, it's not a legal requirement and there is still no defined timescale. We've heard 9 months been kind of thrown about, but potentially in January, if you have a 6-month probation and you review on the last day and you dismiss, you are already at risk as that employee has employment rights. Okay, so you may want to consider, we're already speaking to clients about it in terms of having a shorter probation period, 3 months perhaps, to avoid any risk, or absolutely fine to keep it as 6 months, but make sure that you have a process to manage probation reviews and that they are actually happening. Because just to advise also with regards to notice, if an employee has a month's notice, for example, that you need to give them, notice does actually extend the rights. So if you need to give 1 month's notice, dismissing at 5 months would then add that notice on. So then it becomes 6 months, so there's still a risk. Okay, so just to confirm, short service dismissals, they will still exist. We're not saying you can't get rid of people when you want to. It's just that you need to be done before the 6 months service and those employment rights kick in. So we do hope to get clearer guidance on this as the date approaches, and we will of course keep you updated and advise you on what you may need to consider doing to avoid this risk. We've then got fire and rehire. So this is when an employer dismisses an employee and then offers to re-employ them on a new contract with different terms and conditions. And these new terms and conditions generally are less favourable. So from January 2027, fire and rehire will become automatically unfair in most cases. Okay. There is a small exception. So if a business is in serious financial trouble, in that situation, an employer might be allowed to let employees go and rehire them on new terms, but only if the business might otherwise go under and there is no other way to deal with the issue. So, taking all of this into account, it really is important to consider introducing a probation period if you don't already have one. Conduct structured probation reviews, document any performance concerns, and make sure that you provide written confirmation of any decisions reached. Okay. Additionally, in 2027, workers on 0-hour contracts will gain the right to guaranteed hours if they request them. So they will also gain compensation if shifts are cancelled, protection if shifts are cut short, and the right to reasonable notice of shift changes. Now, what is reasonable is still to be determined, so we will keep you updated on that one. But I guess for businesses that currently rely on the flexible model, it is quite a significant change. So you may need to review your contracts, forecast your staffing more carefully, reduce any last minute cancellations, and budget for potential compensation costs. We then have the flexible working law, which will tighten in 2027. So if you are rejecting a flexible working request, then you must cite one of 8 statutory reasons, which is actually already the case, but there will also be an obligation that you will need to explain why the refusal is reasonable. So whilst this reflects good practice already, it will become legally enforceable. So you will need to make sure that you've got, processes, you've got a policy, and that you've got kind of structured templates and guidance. And then finally, we have the trade union and industrial action changes, which are primarily going to affect those unionised workplaces. So perhaps for smaller businesses, I guess in theory, that impact will be small. However, from February 2026, dismissal for participating in industrial action became automatically unfair. And from October 2026, workers will gain protection from detriment. And there will also be a new duty to inform workers of their right to join a trade union. But as I say, for most SME employers, in theory, this shouldn't affect those daily operations. So, what should you do now? Well, preparation really is key. So some of the things that we would advise, the priority actions are to update your family leave policies. Now, if you are a client of ours, don't worry, we're looking at this as we speak. It may well be to audit your contract of employment before the unfair dismissal changes. We would advise that you strengthen your probation review processes, that you review your harassment policy and those prevention systems, and that you look at doing those risk assessments, that you update your absence management procedure and any reference to SSP and waiting days and essentially remove it, to assess your reliance on 0-hour contracts, and most importantly, train your managers on company policies and processes prior to January 2027, especially on those topics of managing performance and conduct in and outside of the probation period. We believe that the businesses that prepare in 2026 will avoid risk in 2027, and it is all about that whole structured preparation. So, in conclusion, then, there is a need to consider, I guess, the fact that there is that higher financial exposure. There are stronger compliance expectations. More HR and structured HR processes will be required. As we say, preparation in 2026 will prevent that risk in 2027. But I think the key one is that the employees will have earlier protection. So, those businesses that use this year to audit contracts, review policies, strengthen probation and dismissal processes, and upskill the managers will be in a much stronger position by 2027 when the real impact begins. So at Halliday's HR then, in terms of how we can support you, well, we can carry out an audit of your sickness absence policy and your absence management process and ensure of SSP compliance. We can also carry out a gap analysis of your current contracts of employment and your HR policies and procedures. So this means that we'll look at what you already have in place, compare it against current employment law and best practice, and highlight anything that may be missing, out of date, or could be improved. And what we'll then do is provide a clear report with our findings and practical recommendations for any updates or changes to help keep your documentation compliant, consistent and fit for purpose. And if you wanted to go that step further, we can even make the changes to the documents for you. We can also support businesses in redesigning probation and disciplinary frameworks, ensuring that they are consistent, legally sound, and straightforward for managers to apply in real situations, not just on paper. And as we've said, creating that safe and respectful workplace is essential. So on that basis, we can help you write or strengthen your harassment policy, ensuring that you've got the right policy, the reporting processes and risk assessments to address those issues early and confidently. And then for your people managers, we offer practical, down-to-earth training that builds confidence in handling everything from difficult conversations to the day-to-day people management. And as Liz mentioned at the beginning, for ongoing HR needs, we provide the HR advisory support. So we act as a trusted partner that you can turn to for guidance whenever you're navigating through change, managing risk, or planning for growth. So we do have our 2-day line manager training. We have literally just done it with Tuesday and Wednesday this week. But we've got another one running on the 12th and 13th of May. 9:30 till 4:30, both days at our offices in Stockport. So if you want to get booked on or you've got colleagues, then just drop us an email or give us a call to book your space. Okay. Any questions in the chat box, Liz? I don't think I've seen anything pop through, but I don't know if there is, or if anybody does have any questions, please pop them in the chat box and we will take a look. Alternatively, if you do have a specific situation that you want to discuss, then do not hesitate to contact us.
So we've just got one here. So it says, hi, some companies send workers to factories or warehouses. Does this apply to them as well? Because many manufacturing plants hire workers through, employment agencies.
So assuming that this is in relation to the third-party harassment, perhaps. So if you are sending your workers to, another site, which is essentially outside of your business, then yes. Because the obligation is on you to protect your workers, your employees that are out and about at third-party places. Because although the plants themselves might hire workers through employment agencies, the obligation is on your business to protect your workers and your employees. So hopefully that answers that question. Does anybody else have any other questions? If not, here's our contact details for you to be able to get in touch. As mentioned, we will send a copy of the slides and the recording to you. But if there are no further questions, thank you all for joining us. Apologies for the delay at the beginning, and enjoy the rest of your day.
Bye.
Bye, thank you.